everyone. It's a great pleasure to welcome Mr. Parvez Kudroli, sir. Parvez, sir, is a software inventor, patentee, and entrepreneur and has obtained patents for his inventions in India and USA. He has experience of developing and inventing software, drafting and prosecuting patents, patent searching, conducting patent workshops, commercializing patent rights, and managing the software IPs related to that startup company. He is also a registered patent agent admitted to practice before the Indian Patent Office. Parvez Sir's focus at Khurana and Khurana is on consultancy, business development, and client relationships relating to IPR strategy, patents, trademarks, copyrights, and design. He has worked with hundreds of intellectual property creators, inventors, and inventions to help with their innovation and IP protection strategy. Sir is a mentor with Founders Institute and mentored to startup founders on IPR related matters. He has conducted several intellectual property awareness sessions, IPR trainings, programs, and patent drafting workshops for organizations like MSME Development Institute Mumbai, Rajiv Gandhi National Institute of Intellectual Property Management Nagpur, Sardar Patel Institute of Technology Mumbai, GH Raisoni College of Engineering, Nagpur and Pune, Mege Group of Institution, Nagpur, and Institute of Chemical Technology, Mumbai, with Manipal Institute of Technology, Manipal, and Karnataka State Council for Science and Technology, Bangalore, and World Trade Center, Mumbai, and among others. So we welcome you in today's session. Sir, over to you.
Uh, Thank you, Diksha ma'am. Thank you, Anjali ma'am. We'll start the session now. Good evening, everybody, and welcome to the session on IPR and various types of IPR and patents. It's a pleasure to be here. We have about, I think, 1 hour and 15 minutes. We are starting a little late, I think, so we'll try to complete by around 5:15, 5:20 to the extent possible. Yeah. I hope everybody can hear me. I'll just share my screen and we'll start the session. Can you see my screen?
Yes.
Okay, great. So let's start the session. Okay, yeah. All right. So today's session is, the title is designed as a question: how to protect your intellectual property rights. A very active statement: how to protect your intellectual property rights. So we will go through the aspects of how to protect intellectual property rights. But first, we will start off by trying to understand what is intellectual property and what kind of different intellectual properties and intellectual property rights are there and usable. Will not look at all the intellectual property rights type. There are many, but the 4 main types that we commonly use, we will start looking at that intellectual property and the rights available related to that, get a sense of this first, and then we'll talk about how to protect intellectual property rights. And since my sense is today this event is organized for an audience which largely relates to the food industry. So we'll also look at some questions related to food and related aspects of that. Okay, so let's begin. Hopefully, if we have some time at the end, you can also ask questions. I love to have questions during the session, but when there is very limited time, questions during the session itself can be quite a distraction. So, however, if you have something really urgent to ask, you can, ask your question, unmute yourself and ask the question. Yeah. Okay. So, on the screen now, you see the 4 main intellectual property right types. Okay. So, as I mentioned, we look at on the right side of the screen are the intellectual properties that somebody might create. And on the left side of the screen are the corresponding intellectual property rights that one might apply for that intellectual property. Now, when we talk about intellectual property, what is meant? See, property is something all of us know. A house is a property, a car is a property, this mobile phone is a property. Everything we have, physical things, so many things, there are properties. We know property. Now, what is an intellectual property? Intellectual property is different from physical property, which you can hold or test or touch, or if it's a house or a car, you can go inside that property. Now, intellectual property are in the nature of thoughts or ideas or creations of the mind. As such, they themselves, the property itself doesn't have a physical existence, even though you can translate it into physical things. You can use that intellectual property to affect or impact or make a difference to physical things out there. But the property itself or the thing that is created is more in the nature of an intangible idea or a thought or a concept, right? But this idea, thought, or concept should relate to either maybe to some technology or through some branding related item, or some, it should be, the idea should be for how, what kind of story will I write, or what kind of music recording will I do. So such kind of thoughts or concepts or ideas are called as intellectual property. They are intangible in a sense, the essential creation that somebody comes up in their mind. It's these kind of thoughts or ideas are created in somebody's mind. They originate there. And the essence of that property, it lies in the thought or in the idea, which is intangible. Now, things like a house to protect or secure, or a car, you lock these things, it's in your control, nobody can get into it. My mobile phone, somebody sees in my hand, they assume it's my property, nobody will usually try to steal it from me. So physical property, easy to protect and control and keep in your custody. Okay, but with ideas, with thoughts, with concepts, an idea for a new product, an idea for a new song, you record a new song. Now these kind of things are very difficult to protect, intangible things which don't have a physical reality and physical control, very difficult to protect, because once the idea or one copy of it is out there, thousands if not lakhs of copies can be made and distributed to everybody, and the person or the team of people or the organization which created that intellectual property then has no control over it. So they are the ones who create the intellectual property. They spend time, effort, and money creating the property, but others, once they get the idea or a copy of the work, intellectual property, it's very easy for them to use, misuse, distribute, and basically destroy the market for the intellectual property that I might have created. So that's not a good situation. It's a tough thing for intellectual property to be properly documented and controlled, and to ensure that nobody copies it without permission. So these kind of intellectual properties, how do we protect them? On the right side of the screen, you see what is the intellectual property or thought or idea or concept that somebody may come up with, and what are the correct type of intellectual property rights that one should apply for. So suppose I come up or you come up with an idea for a new technological product or process. Okay, there is an existing mobile phone. Okay, somebody comes up with an idea, okay, we will make an improvement and in the display screen of the mobile phone. The mobile phone is in existence, the display screen is in existence. Now somebody comes up with a way, somebody from that technology domain, he has been working in the mobile phone display screen industry for many years, and now that person comes up with an idea, if we make a display screen with this modification or this improvement, that display screen will consume 1/3 of the power that current display screens consume, right? So what is the idea? This person is not inventing the mobile phone or the display screen. These technologies exist. What this person is doing is improving the display screen technology such that it consumes 1/3 the power. Means on the same battery charge, the phone will last much longer without charging. Okay, it's a great technical innovation in the physical product called the display of the mobile phone. Now somebody somewhere gets that idea. If we modify this screen or its manufacturing process, means we modify either the product or the process, then the display will consume 1/3 the power. When this is the idea that they get, and they will also document what is the particular modification they will do in this existing product or process. Now this is the technology idea, this is the technology invention. Now once this person tells somebody about it, or once this company for which he works incorporates this technology into their display screen, and there's some documentation of that, everybody including the competitors come to know how to make that better mobile phone, display screen and everybody benefits. But this is the person or company which has invented, they want to have exclusive control on this technology and not allow others to copy without their permission. So what will they do? They will go and apply for a patent right on this technology. How was the display, the product itself, or the process for making the display, the process invention created is documented, and then they say we are the ones to create, we are the ones submitting a copy of this invention to the patent office, and we want a patent right. So here the idea, the intellectual property, the concept is a technological invention, any new or improved product or process, and the right that you apply for such technological inventions is a patent right. You will apply for a patent right from the government. Once the government conducts the examination of the application and issues a patent certificate, using that patent certificate, you are now allowed to go and stop other people, other companies from copying your invention idea and implementing it in their mobile phones. They are not allowed to do that without your permission, because now you have a government certificate authorizing you to stop copiers. That's what a patent certificate means. It's an exclusive right. You get the right to exclude other people from copying your invention without your permission. If you are willing to allow, if you permit them, then they can copy. Without your permission, they cannot copy. This is the nature of IP rights, or especially the right related to patents. It's a right to exclude others from copying your invention. So what is the intellectual property that is created? It's an idea, a thought, a concept for a new or improved product or process. And what is the IP right that you apply for? That is a patent right that you will apply to the patent office for, and get that right hopefully after due examination, if the invention is new, inventive, and useful. Okay. The second line that you see, the second type of intellectual property and the corresponding intellectual property right are the intellectual properties and aesthetic design of industrial products. Suppose now, what you'll ask, what is an industrial product? So this bottle that you see is an industrial product, and you can see that it has a certain shape. This mouse over here is an industrial product. The table on which this laptop is kept is an industrial product. This laptop on which I'm conducting this session is an industrial product. This headphone is an industrial product. Cars, bicycles, chairs, pencils, all kinds of things are industrial products. Now, there are certain design elements that you might build into this product. For example, the bottle or this mouse, the shape of it. Now, that shape might be unique in the sense that it looks different. It is aesthetic. It is pleasing to the eye. But the shape of the mouse this mouse has doesn't make a difference to its working. It's merely a good looking aesthetic shape. Now, such designs, such shapes are protected through industrial design registration. That is the right that you apply for. So suppose you have given a design to an industrial product which makes it look good, attractive, aesthetic, but doesn't really affect the functionality or working of that product. So these are merely good looking shapes or designs, aesthetic designs that you are applying to any industrial product. Then the correct type of IP right that you should apply for will be an industrial design right that you apply for. So the patent will protect the functional, new and inventive design, which gives some functional benefit in the usage. Like in case of the screen we saw, the functional benefit is the display consumes 1/3 the power. That's a functional benefit. It's not merely display looks good. Display looks as it was. Okay. But the functional benefit, when it's there, that's a technical invention. So you apply for a patent for technical inventions. For designs which are merely good looking or aesthetic, which are applied to industrial products, you will file an industrial design registration. Now somebody will ask, why protect these good looking designs which don't make a difference to the functionality or usability of the product? Why good looking designs? The answer to that is, good looking designs applied to industrial products have value. Why do they have value? Because the people who buy these products, human beings, are emotional beings. If they are using a mouse, they don't want an odd looking, ugly looking, square shaped or rectangle mouse. They want a nicely designed, curved shaped, good looking mouse. Even though functionally it doesn't matter, but still they want to use a mouse which is good looking. People want to use a mobile phone which is good looking. They want to drink water from a bottle which is good looking. That's why aesthetic designs have value. Aesthetic designs applied to industrial products have value from the perspective of the users who are emotional beings and who like to use or work with good looking things, merely not things that work well, but which also look good. That matters to human beings. That's why industrial design registration, that IP right has value. Okay? Now, third line that you see, what is the intellectual property? These are the brands, logos, word marks, and taglines which are used to identify the source of origin of a product or service. Okay, so any items or marks that are used for identifying the source of origin of a certain product or service, for that you will apply for trademark registration. Now, for all of these things in the coming slides, we'll look at certain examples of these things to make all these things more real for you. Okay, so a brand, for example, my phone is a Samsung phone. It's written over here. Okay, a Samsung phone or an Apple phone, knowing which, just having a phone is not enough. People also check, what phone do you have? An iPhone, Samsung phone, or OnePlus phone, or Xiaomi phone, or what kind of phone. So all these names, these are trademarks because it identifies from which company this phone is coming. All these are phones, but from which company is that phone coming matters. Each brand has a certain value, a certain identification, a certain value proposition and placement in the market. Okay, and a certain quality levels are expected based on what company it is coming from. So brands, logos, word marks, taglines, they identify where that product is originating from which is the entity or person or company which is creating that thing. And those kind of marks are protected through trademark registration. And the last category of intellectual property that you see on the screen is literary, artistic, musical, cinematographic works. These are expressed works. A literary work, for example, is a book. Somebody writes a book. So there is a book in existence which has words, lines, paragraphs, pages of words over there. Now that once that person has written that book, that expression is fixed permanently forever. It is not going to change at all. It will remain the same. That book will, even after 100 years, if you pick up the book and read, the same lines, same words, same paragraph, same photographs will be there in the, these are expression. That's a fixed expression. These are expressed words. Similarly, if somebody records a song, very nice music and nice songs and nice words, and they record a song, now that is also an expressed work, and that can be heard by people and then enjoyed. Similarly, audiovisual recordings or movies can be protected through copyright. When the expression is fixed, the value of the work is in the expression, then you can protect such works through intellectual property rights. So for literary works, photographs, paintings, cinematographic works, musical works, expressed work, where there's a fixed expression, those things, and the value largely of these work is in the expression itself. For example, suppose imagine Dharma Productions, Karan Johar, he makes a movie. Okay, he spends 1 year and 100 crores of rupees, employs countless people, all the actors, the technicians, the support staff, so many people, highly skilled people working 1 year. And Dharma Production, is working on that. They hire a director, music director, art director, all kinds of people working 1 year, 100 crores spent. At the end of 1 year, what do they have in their hand? Nothing except a movie recording. Okay, and that's the expression of the work that they have done. Where did that 1 year go? Where did that 100 crores go? It went into creating that movie recording. And what is the value of that movie? Value of that movie is in the expression. When somebody just sees that sound and that video in a movie theater or at home, okay, and they're just sitting there and looking at it, there's no functional value that I will get if I watch that movie, by the way. Okay, if I'm looking for a job, by watching that movie, I don't get a job. Okay, if I'm feeling unwell, just by watching the movie, I will not get okay. If I don't have money, by watching that movie, I don't get any money, right? So no functional value to that movie, but still I like to sit in front of the screen in the theater or the TV at home and spend 3 hours just sitting there and watching and hearing, right? Why? Because emotionally I enjoy watching good movies, seeing the video, hearing the song, the dialogues, etc. I perceive that the expression is the movie recording, and the value of that expression is in the perception of it, in just watching that expression. That's the value. Other than that, can you understand, can you see that there's no functional value to any movie or to a book or a song recording or a painting? You just look. A painting you perceive by looking at a painting. A book you perceive by reading it. A song recording you perceive how? By listening. And a movie, how will you perceive? By looking at the video and hearing the dialogues and so on. So can you see these are all expressed works which can be perceived in different ways? The expression itself is protected it's in a fixed form, and that is protected through the copyright that the author of that work or the creators have on that. Okay, so having a copyright on a movie means once I have made a movie, I have a recording and I have distributed the copy so that it can be shown in cinemas. Okay, and I can make money, and somebody gets a unauthorized copy of it and they start distributing it, showing it to people and collecting money. They are not allowed to do that. Why? Because on this intellectual property called this movie, this expression, I have a right called a copyright, and under that copyright I can go and take action against anybody who makes an unauthorized copy of that movie and starts distributing without my permission and without any benefit to me. Okay, this is the relevance, significance of the intellectual property that people create, which can be easily copied once it's out there, and the intellectual property right that you get on it to make sure that nobody copies that freely without my permission, without the permission of the creator of that intellectual property. That's the whole idea. Okay, so patents you get so that nobody copies your technological invention. Industrial design registration you get so that nobody applies your aesthetic design to that particular industrial product. Trademark registration you get to ensure that nobody can copy and get away with copying your brands, your logos, your wordmark, and misrepresenting the source of origin of the product or service that you provide. And copyrights you get so that you can, or you try to protect that so that you can ensure that nobody makes a copy of your book or your song recording or your movie. In case they do, you can take legal action. Government allows you to take legal action because you have a copyright on that. I hope this concept of intellectual property and the rights you get on it is clear. Please note, to a large extent, now the statement I'm making now is not 100% true, but to a large extent, if you have created intellectual property and you start distributing it just like that without taking any steps to protect it, guess what happens? Then it becomes free for all, everybody, your competitors, your neighbors, your friends, people you don't know, and their uncles and aunties. Everybody can copy it freely, benefit from it, enjoy it, make money out of it. You get nothing. That's why it's very important that you protect your intellectual property related to whatever you have created through an intellectual property right, through a proper government certificate, government authorization. And then in case people copy, then you can take legal action against them. And if people know that you got the correct kind of intellectual property right on your intellectual property, they'll hesitate to copy it and misuse it because they know you have the intellectual property right certificate and they can take action. You can take action against them. That becomes a deterrent for them to misuse and copy your intellectual property. That's why it's so important to take action to get the right. You don't get intellectual property rights automatically. Usually you need to take action, register it properly, the intellectual property register, and get the right from the government. Only then your intellectual property has some protection. Now again, enforcement of that right is a different question, but at least you have some ground for saying I've taken action to protect this. Now on the screen, out of the two intellectual property rights at the top of the screen and the two at the bottom, the big thing to understand about patents and designs is, unless it's very important that when you come up with an idea for a new invention or a new aesthetic design applied to an industrial product, if you want to protect this, you have to first go and apply to the patent or the design office before you make this invention or this design public. If you come up with an invention, you actually tell people about it, or you make products and sell, incorporate that feature into that product and start selling in the market, and then you think, oh, now I'll go and file a patent. By then it's too late, because the criteria for grant of a patent is, as of the date of filing of the patent application, your invention must be new, inventive, and useful. If you have already made it public, it's no longer new and inventive, it's old. Therefore, the patent office will reject your patent application. Same thing, the design, aesthetic design applied to an industrial product is expected to be new as of the date of filing of your design application, right? If it's not new, you may already made it public and then applied, then there is a problem. Your application will get rejected. The same does not apply for trademark and copyrights. You may very well create a logo or a wordmark or a tagline and use it for years, and after a few years you can go and apply, no problem, right? The trademark application will be strengthened if you can tell, last 5 years I've been using this mark, this brand, this logo, this wordmark to promote my products. That will actually strengthen your application. It will not disqualify your application. Same thing, copyrights. The moment a work is created, you automatically have copyright on that without doing anything. Automatic copyright the moment the work is created, right? So there is no necessity to go and register a copyright, but it's better to register both copyrights as well as trademarks, even though they are not mandatory to register, because in case somebody copies or there is a dispute on ownership of this, then what happens? The matter will go to court. You will go to court. The person who's copying your intellectual property, your marks or your copyrighted work will also go to court, and both will make similar claims. This brand belongs to me. This copyrighted work, this movie, this song recording, both you will say that, and the copier will also say that this belongs to me. I have a trademark or copyright. Now, how will we come to know, or the judge come to know, who has ownership on this and who is the rightful owner of this brand or the trademark or the copyright? For that's the reason. So in such scenarios where you haven't registered your IP related to the trademark or copyright, the initial part of the case, maybe 6 months, 1 year, 2 years, will be spent in just establishing your ownership. First, you'll have to spend all that time, effort, and money, hire lawyers just to prove that you are the real owner, right? After that, the actual case against the copier, the infringer, will start. On the other hand, if you already have a trademark certificate, or you already have got a copyright certificate, or at least you have applied for it, then when the dispute goes to court, you can show this evidence. See, I have this certificate which proves that I am the owner. So no dispute on that. The other party can't say anything. So now the case will only be about what has the copier done. Why did he copy? To what extent has that copier caused damage to me through the unauthorized copying, and then what to do about that? So the case directly gets into the meat of it, the main subject matter, which is what to do about this infringement and how to remedy the situation. No time, effort, and money is spent by you trying to first prove that, oh, you are the real owner of this intellectual property. Okay, because the other guy is also making the same claim. Nobody has ready certificate to prove their ownership. That's why registering even trademarks and copyrights for important marks and important artistic literary works is very important. Okay, right? Even though it's not a must. So I hope there is clarity about the various 4 main types of intellectual properties that we might create, and what are the intellectual property right on the left side of the screen that you should apply for. Okay. Why this is important to understand is, suppose you have written a book or you have developed a software program. Don't go and file a patent for that, or don't file a trademark application for that. Or if you have come up with a good, strong technological innovation, means an idea for an improved product or an idea for an improved process, don't document that idea and file a copyright. Copyright on a technology invention, even if you get a copyright on that documentation describing the invention, gets you no protection. You're giving away the idea to the world for free. Okay, so very important to firstly understand what's the intellectual property you have created and what is the correct type of intellectual property right that you should apply for. That's why it's important to understand what is written on the screen, the difference between the various intellectual property that you might create and the corresponding intellectual property right that you should apply for. Let's go to the next screen and see some examples. Example, what IPR should I apply for? I have created a new product design. Now, the question that arises is, should I file for a patent or should I file for a design registration? So on the left side of the screen, you see a plain glass. Okay. Now, assume that this glass is very old and already known, very plain, simple glass, nothing new nothing innovative in that. Okay. But then imagine now is the time when somebody has created a new glass design. The glass you see in the center of the screen You can see that the design of that glass is different. It is very aesthetic, curved shape design, looks much better than the glass on the left. And this is a new design. The question that arises is, should the creator of this new glass design file for a patent or an industrial design registration? Now, I think everybody pretty much will say, okay, because of the new design of the glass in the center of the screen, there is no difference in the working of the glass. If I'm drinking some water, the water will not taste sweeter or sour or hot or cold just because the glass is curved shaped. So functionally, having a curved shaped glass makes no difference to me. So we can't apply for a patent, doesn't make sense. However, the glass looks very aesthetic. It has a nice shape, good looking design applied to an industrial product called a glass. Okay, industrial product is glass. A good looking curve shaped design is applied to it. So what we should apply for here is a industrial design registration. I think everybody will agree with that. Okay. Now let's go further in this example. Look at the glass on the right side of the screen. It's the same plain old glass on the left side of the screen, but this glass has an additional feature or additional part, which is the handle of the glass, right? Now the question is, should I file for a patent for this new glass on the right side of the screen, or should I file for an industrial design registration? Think about it. If anybody wants to answer that, you can unmute yourself and answer. Should we apply for an industrial design registration for this glass on the right side, or should we apply for a patent right on this glass? Think about it. Because of the handle, suppose you're drinking some hot water or liquid, having a handle is very convenient. Holding a glass with hot water is inconvenient. My fingers will burn and I might drop the glass, right? So having a handle is a very good functional feature. It helps me comfortably drink a hot liquid or water from the glass. Can you see it's a functional feature, functional design element, right? So because of that, can you see that you can very well file and obtain a patent on this glass design on the right, because it's a glass with a handle, and the handle has a functional benefit. It's a functional technological improvement of the glass. It's more easier now to use the glass, right? So you can apply for a patent. But the question that I'll also ask you is, do you think it's possible to also have an industrial design registration on the glass on the right side? The answer to that is yes. Now, why? Because this glass on the right looks different from both the glasses on the left side, right? Can you see the shape, the appearance, the aesthetic of the glass on the right is different from the other two glasses. Therefore, it looks different. It has a different shape. It has an aesthetic design. Therefore, you can very well apply for an industrial design registration, right? So can you see that when the design office says industrial design registration is for an aesthetic design, aesthetic doesn't necessarily mean a better looking or good looking design. What they really mean is a different looking design. As long as your design which you're applying to your product is different looking compared to existing designs, you can get that design registered as an industrial design. This is the learning that we get from this example over here. Okay. So you can see an example here of a product which has a new design, and a patent can also be filed, and an industrial design application can be filed, and both can be obtained. By the way, if you're filing both, file them on the same day so that one does not make the other application old or prior art. One doesn't become a prior art for the other application. Okay, right? Now, just think, can you think of a product where the shape of the product, okay, is a functional shape? It makes a functional difference, but the shape is so distinctive, okay, and the function actually is dictated by the shape given to the product, such that if you file only a design application for that shape given to that product, you will get the benefits to a large extent even of a patent application for that kind of a design. Okay, so there is a functional design to a product. Now that functional design, normally you would say, let's file a patent, but it so happens the functionality of that design applied to that product is so critical to the working functionality of that, the shape is so critical to the working of that product, the functionality, that you can very well file a design application and protect the functional aspect of that particular design. Can you think of a product like that, where the shape itself dictates the working and functional benefit of that product. Therefore, if you apply only for an industrial design application, even that will be enough. Can you think of a product? It's a very commonly used products. There are products very commonly used which have this characteristic where the shape itself is dictating the functional benefit. Therefore, if you only apply for the shape, the industrial design registration, you protect even the functional benefit that can accrue from that particular design. Can anybody just mention or type in what could be that product? Any example of such products? Okay, let me go further on this slide and you can see the example over here. Okay. Okay, now look at the bottom of the screen. On the left side, you see a plain old existing fan. This is known design and known technology. Now imagine somebody has created the fan on the right side with that very nice looking curved shaped design of the fan blades. Okay, now because of the aerodynamic curved shape design of the fan blades, the fan is able to actually is more aerodynamic and it can actually circulate more air. It provides more air circulation. And what's the functionality of the fan? The functionality of the fan, the reason why we have fans is to circulate air, and the curve shaped aerodynamic design circulates more air. So can you see that because of the new aesthetic shape given to the blades, the fan is functioning better? There's a functional benefit. Therefore, you know that you can very well file a patent. But when you look at the fan, can you see that the shape is very distinctive and aesthetic and it looks different compared to the existing fan? So you can very well apply for a design registration for this new fan design. Now question is, which one will you apply for? Okay. Now this question, if you ask to a business person, their decision will come very fast, because what happens is, compared to an industrial design registration, a patent application is much more costlier in terms of time, effort, and money, maybe probably 10 times or more costlier than an industrial design registration. The cost of getting a patent will be 10 times or more compared to getting a design registration, right? So what the business person will think is, okay, if I apply only for a design registration, I am spending less than 1/10 the time, effort, and money. My design is, the shape is protected, and if nobody else can make this shape, they can't get the benefit of that better air circulation due to the aerodynamic design, because the design registration protects the shape of the blade. So without filing a patent application, filing only a design application and protecting the shape, you are also protecting the functionality of the product. Normally, to protect functionality, you will file a patent application, but that's more costly. So the business person decides, okay, very quickly, in fact, the person will decide, I'll file only an industrial design application. My protection will not be 100% as strong as a patent protection. Maybe it will be 50-60%, but my cost is less than 1/10. So I'll only apply for an industrial design registration on the shape. That gives me protection on the functionality to 50-60%, and that's it, end of story. And so in this way, the business person is doing a trade-off. I'm spending less than 1/10 the amount and I'm getting 50-60% of the protection. And the business person feels there's a very good trade-off to do. These are the practical aspects of protecting IPR. Just because you can file a patent, you need not rush to file a patent. You have to consider what's the value and sense of doing such a thing. Now let's look at this example. What IPR to apply for? I have created a new logo and a new tagline. Logo is an image, and a new tagline phrase. Should I file for copyright or trademark registration? Okay. Now, can somebody tell me what is that logo, that image that you see on the left of the screen, and what is this phrase on the right side of the screen? Or who do these belong to? Can anybody tell? Right, somebody has typed here Pepsi. Okay, so these are actually marks, trademarks of this company called PepsiCo, which has this brand called Pepsi. The PepsiCo company sells product with the trademark Pepsi, and the logo on the left is the Pepsi logo, the image. Okay, and the phrase on the right is a tagline used quite some time back. Earlier they used to use it for their product, especially their drink. Okay, and even recently, this phrase "Ye dil mange more" was made very famous when the film Sher was released. Okay, as many of you would know, and many of you actually might have seen the movie also, right? This phrase "Ye dil mange more" was actually said and uttered on TV by the real Captain Vikram Batra in 1998 or 99 during the Kargil War. This is the statement after capturing that very difficult point. Captain Batra actually said this, "Ye dil mange more." He wanted to go and capture more, strategic peaks over there. Okay, so this was actually a tagline which Pepsi had been using for many years before that. And can you see the power of this tagline? How people identify, and Pepsi used it to identify the source of origin of its product, and how it stuck even in the mind of Captain Vikram Batra. And when he captured that peak, that point, he said, "Ye dil mange more." Right? Just imagine the power of brands, logos, taglines, and marks. Okay. Now, this you want to protect. If Pepsi has created this, they don't want other company somewhere, some company somewhere in Tamil Nadu or some West Bengal to use their logo without their permission and sell spurious counterfeit drinks. Okay, and enjoy the goodwill that Pepsi has due to its quality of its product. Okay, so that's why protection of your word mark, your logos, your taglines, your trademarks is critically important. Okay, now if you see the image on the left, it's an image, like it's a photo, right? You can very well copyright it. The line, the phrase, the tagline that you see on the right, it's a collection of words. You can very well copyright it. So you can very well copyright these marks, or you can trademark register. Now, what will you do? Okay. Now, both can be done, and maybe Pepsi has registered a copyright also on these, and they might have registered the trademark also on this. But can you see, considering the purpose and the usefulness of the mark as branding elements, they are used for doing branding for this company, the trademark registration is much more important than the copyright registration. Right? So first, anybody will rush to register the trademark on these kind of marks, and if they want later on, if they have a lot of money to spend, then they may also register copyright. Both can be done. But really what matters for this kind of intellectual property, right, this kind of intellectual property is trademark registration. Get this. So it's not that you can do this and that and that and this 10 things you can do, so you do all 10 things. You will evaluate, to my business, to my work, to my intellectual property, what is really important. I'll, out of 10 things, I'll only do that 1 or 2 things which is really important for me or my business. That's what you'll do, even though everything is possible. Okay, this is a very important thing to understand, because IP protection is resources intensive. It's not cheap. It costs not just money, but your time and effort goes into filing, prosecuting, following up, doing all these things. A lot of time, energy goes into it. You would rather be focusing on your business, on your operations, on your marketing, rather than on IP protection. It should not take too much of your time. So focus, prioritize, and file only for those things which are really essential for you. Okay, now let's go to the next slide over here. Okay, right. Now let's quickly go through the 4 intellectual property right and intellectual property types to get a sense of what is the procedure for how to protect your IPR. What is the procedure and requirements for protecting your, firstly the patents, then the copyrights, then the trademarks, then the industrial design, how to do that. Okay, now when it comes to patents for invention, invention is the intellectual property, patent is the intellectual property right. What can be an invention? A product or process, or an improved product or process. The patentability criteria. What are the criteria for grant of a patent certificate for your invention? The invention as of the date of filing of the patent application should be new, inventive, and useful. Means different from anything that exists, not just in India, but across the world. Nowhere in the world anybody should have publicly used or disclosed your invention. Only then you can hope to get a patent granted. Is registration required? Yes. Before you use or disclose in public, first go and apply to the patent office for a patent grant before you disclose it. If you already disclosed it 1 month back and 1 month later you go and apply, your application is liable to be rejected. Okay, what is the term of the patent? Up to 20 years from the filing date of your application. That's the maximum term. So after 20 years, your patent right will expire, intellectual property is still there. And when the right expires, your right to stop others expires, everybody can start copying after 20 years legally. That's what term of 20 years means. After 20 years, everybody can copy it. Your patent term lasts only for 20 years from the date of filing. Okay. What are the requirements? You have to give a detailed technical description and drawings of the invention. Based on that, somebody who's good at drafting and filing patent applications will file that and try to obtain a patent for that technology. Okay. What are the costs? There are different costs related to the searching of prior art, filing the application, replying to the objections raised by the examiner in the examination report. And once a patent is granted, you need to renew the patent every year. You have to pay a renewal fee to the patent office for renewing a patent application. And please note, you can an Indian patent will protect your invention only in India. It applies only in India. If you want to protect your invention in foreign countries, you have to go and apply there, claiming priority of your Indian application, and the cost there will be separate for that foreign application. Okay, just keep that in mind. An Indian patent can't be enforced in USA or Europe or Japan or Australia. It can be enforced only in India. But once you filed in India, you can claim priority of your Indian application and go and file there within certain time limits. There are systems and ways of doing that. Okay. Now, then let's look at the next one, which is the design registration for aesthetic designs. Aesthetic design is the intellectual property. The IP right on that is a design registration or an industrial design registration. What will you register? The aesthetic design applied to a product. What is the registration criteria? The design must be new. Is registration before disclosure a must? Yes. Okay. What is the term of the design? 10 years from the filing date. And at almost when the 10 years are up, you can apply for extension by another 5 years by filling the form and paying that extension fees. So maximum term of a design registration can be 15 years if you seek extension also. Okay. What are the requirements? You have to give a very brief 1 or 2 line description of what is that product or industrial product to which you are applying the design. For example, you'll say a mobile phone with a unique design. Okay. So now somebody knows that this application is for a design applied to a mobile phone. This application is not for a design applied to a bottle of water. Okay. So that people want to know. And then you give images or views of the actual product. So I'll give images or views, which could be photographs or they could be CAD/CAM drawings of the actual product, how it looks from all sides, means front view, back view, left view, right view, top view, bottom view, and at least one perspective view. So somebody knows how it looks like, what is the new design applied. Okay. And what are the costs involved? There are costs related to filing. Examiner will issue an examination report with objection. You have to reply to that. And later on, suppose you are seeking extension, then you have to pay fees for that extension. Again, based on your Indian filing, within 6 months, you have time only of 6 months where you can go and apply for registration in any foreign country if you want to protect your industrial design in a foreign country. In a patent, when it comes to a patent application, once you file in India, you have 1 year's time, and there are more systems to do foreign filings. In design registrations, it's more limited time, 6 months. Under the Paris Convention, you have to go and apply in that foreign country. Now let's look at the intellectual property called brands or word marks or logo marks, and what is the IP right, which is the trademark registration is the right that you get. What to register? Logos, word marks, taglines. What is the criteria? The mark should be non-descriptive and different from others. It should be distinctive and not a commonly used word. For example, if you are a soap manufacturer, you can't get a trademark on a descriptive word like soap. You go to the trademark registry and say, I'm manufacturing soap, so I want to register the mark soap, SOAP, soap. I want to register this. Do you think the trademark registry can grant you a trademark registration on the word soap? No, they cannot, because if they give you this right, then all other soap manufacturers will have to call their soap as Apple, Orange, or mobile phone. They can't call their soap as soap because you've registered it as your trademark. So a trademark registry cannot give a descriptive word or word mark as a trademark. It has to be some other name. If you are selling soap, call it wheel. You people, many of you would be aware of there is or was a soap in the market which was not called soap, it was called, the trademark was Bheel. Now that is allowed. Okay, because all other soap manufacturers will not have Lux will not have a problem that this guy is calling his soap as Wheel. Oh, fine, do it. We'll call our soap, our brand is Lux, your brand is Wheel. Both are selling soaps. Okay, that is fine. So non-descriptive and distinctive or different from other marks. Registration required. It's recommended but not essential. Recommended for the reasons I explained. In case there is a dispute, somebody is copying, if it is registered, you don't have to first prove your ownership. You can just ready show the certificate. This is my trademark. Now you are infringing. Let's talk about damages. That's how the case will go. When to file? You can file before you start using the mark or after you start using. After 5-10 years of using also, you can go and apply for registration. Assuming in the meanwhile, nobody has made things difficult for you by applying for the same thing with the trademark registry. Then it becomes complicated. Okay. What is the term of the trademark? Please note, perpetual. Trademark doesn't necessarily have to expire within a certain period of time. It can go on for a very long time. As long as the conditionality is this, subject to use and renewal. Suppose a company is using a trademark for 50 years or 100 years or 200 years. Now you can understand a person will not live 100, usually 100 or definitely not 200 years, but a company can live for 200 years, right? And if for 200 years that company is using that mark, and every 10 years that company goes and pays, applies for renewal and pays the fee, that mark can continue for 200 years or more also. There is no, final date. From this date, the trademark can't continue. It's a perpetually usable and renewable intellectual property, which is very different from patents or designs or even copyrights. What are the requirements? You have to give the logo image or the word mark or tagline and mention what kind of products or goods or services you're providing in the market. Are you selling mobile phones, or are you selling cement, or are you selling cold drinks? Which industry are you in? You have to mention that along with the mark itself. There are costs involved for filing, dealing with the trademark registry and their objections, and after it's granted, periodic renewal. Now, foreign Indian trademark right doesn't give you a right across the world. For that right, you have to go and apply in those countries. You have systems, under the Paris Convention, you can go and apply in each country, or you can file what is called one common Madrid Protocol application for multiple countries. So both these options with certain pros and cons are available. But note, an Indian trademark registration doesn't grant you a right in a foreign country. You have to do that separately after mentioning or telling the office about the Indian application or Indian mark which is registered over here. Okay. Now let's look at the final type of intellectual property right, which is the copyright. Okay. Now it's come. Okay. Now copyright registration for what? What is the intellectual property? Expressed works. Okay. What are expressed works? A book you have written. Okay. A photograph you have taken. A song that you have made a recording of, a movie or an audio-visual recording. These are expressed works. Once they are created, that expression is fixed unless you create some other different work. Okay. And what is the IP right that you should apply for? Copyright registration, which by the way, I mentioned to you is automatic, but it's better for important works to get a proper copyright registration certificate from the government copyright office. Okay, that clearly establishes your ownership on that copyright. Okay, what to register? Literary, artistic, musical, cinematographic work, and as a special category, software programs also can be registered under copyright, because the program itself is an expressed work. Registration criteria: the work is supposed to be original, created by the person that is mentioned in the application as the author or the creator of that work. It should be original. Somebody else's work, you can't file a copyright application and claim to have copyright. Okay, that doesn't belong to you, so you're not allowed to do that. Okay, registration, is it required? No, it's not essential, but it is better, it is helpful, at least for important works, to register the copyright. When to file? You can file the copyright application before you make it publish, before you publish it, or even 2 years or 5 years or 10 years after publication. Just assuming that in the meanwhile nobody gets a copy of it and then files a copyright app, then it complicates matters for you. What is the term of the copyright? 60 years from death of author or if it's kind of a collective work by some entity or organization, then 60 years from the date of creation. What are the requirements for filing a copyright application? You need copies of the work and fill up the relevant form and do the filing. What are the costs involved mainly for filing? A copyright is not examined in detail. They'll just check, oh, have they filled the form? Have they paid the fees? Is the name of the applicant, author given, and address given, etc. And based on that, through a overall kind of a very casual or non-substantive screening, they will register the copyright without doing a detailed examination. So usually only filing costs will be involved. Okay, foreign filing is not required because there is an international treaty called the Berne Convention. Under that, if you have a copyright in one country, for example, in India, that copyright is upheld, it's valid across the world. Okay, so as an Indian, you may have a copyright over here if you have some way of establishing your ownership either through a copyright registration or some other documentation that this is your copyright, that will be upheld and held valid in any country of the world which is a signatory to the Berne Convention. Okay, now there will be some odd countries like North Korea or Cambodia or I don't know, some Taiwan, which may not be signatories. Most countries will be signatories to the Berne Convention. Okay, so your copyright will be upheld there. And in fact, there is even a possibility you can apply for a copyright with the US Copyright Office. Okay, the US government copyright office, you apply, and once they give you a certificate, that certificate will be valid in other countries of the world, including in India also. So some people even do that for various reasons. Okay, now let's go to the next slide. Okay, now coming specifically, since the interested audience may to a large extent be people from the food tech industry. Okay, let's look at some points related to IPR protection for food tech or food related items. Firstly, if anybody, I don't know whether anybody has had this question in their mind, can food be patented? I have come up with some new food. Can I patent it? Have you had questions like this coming in your mind? Maybe some of you might have had that question. Okay. Now, first thing to understand about patenting some. Now, can food possibly be qualifying as a patentable material? The answer to that is yes, possible. It is possible. Okay, as long as it meets all the criteria. There are the three main criteria we saw, plus there are other subsidiary criteria also. As long as it, because food is a physical product, you can touch it, you can eat it, you can hold in your hands, right? And if the food is new and innovative, maybe you can, right? Okay, but the question that will be arising is there a technological innovation in that food? Okay, टेक्नोलॉजिकल इनोवेशन आइडिया क्रिएटेड बाय यू के ऐसा बनाएंगे या ऐसे करेंगे या ऐसे ग्रो करेंगे या ऐसा प्रोसेस फॉलो करेंगे, something new technologically has to be there for it to be patentable. For example, suppose you grow rice in your fields. Okay, do you think you can get a patent on your rice? No, you cannot, because you have not done anything innovative. Rice has been grown on this planet for thousands of years, tens of thousands of years. Everybody's been growing rice. The same rice is growing even now. So nobody can now it's public property. It's commonly known, nothing new and inventive in that. So you can't go and get patent on rice. Rice is a naturally grown product. Okay. Similarly, other food items which are naturally grown, cotton, if you grow, then you say, oh, this is already been grown. Can we patent it? No, not really. Okay. Now, suppose somebody does something which is genetically modified. Maybe then there is a possibility of patenting that, because something new and different is deliberately being done in that case. So that might be patentable. Or it's not naturally grown stuff, but suppose you're making some new dish which nobody till now has made. Okay. So this is where we come to the second question or point in this on the screen. Can a new recipe be patented? There are so many recipes for making so many different things. You can make cake, you can make dosa, you can make idli, you can make biryani, you can make puran poli, you can make samosas. So many different food items can be made by people. There is a new product. A samosa is different from a dosa, which is different from a misal pav or some other product, puri bhaji, right? These are different products. Can they be patented? This is the question. Okay, so effectively you're saying, can the recipe be patented? Recipe is what ingredients go into a certain dish and what are the steps to be followed to make it. There are so many dishes being made using so many different ingredients in different combinations. So different steps are followed in different permutations and combinations, and different ingredients are used in different recipes for making different dishes. Now here, can somebody tell me, can somebody unmute yourself and just share your thoughts with me? Do you think a recipe can be patented? Or do you think it should be copyrighted? Or you can't do either of this? What do you think is possible? Is it possible to protect a new recipe that somebody creates? This is my question. Somebody can you please unmute yourself and try to answer this or share your thoughts? That will be very enlightening for everybody who's participating in this session. So somebody has typed no over here just now. So this is now. So you people are saying that you cannot patent a recipe. You cannot maybe copyright a recipe, or you cannot protect a recipe. Correct? That's what maybe you might be saying. Okay, right? Because I think most of us are aware, somebody makes a new recipe and they publish it, everybody else starts making that dish, and there's no action taken against those people, right? Now, let me differentiate and clarify this whole question of, can a recipe be patented or copyrighted or protected in any manner? Okay, let's look at this question. Now, what is a recipe? It's a combination of various ingredients to make a certain dish and the steps to be followed. In one dish, you will actually boil something, cool it down, and then put something in it and then fry it. In another case, you might actually fry it first and then dip it, cool it down by dipping it in maybe some curd or something, and then do something. But can you see the building blocks that go into making every dish? The building blocks, the individual elements, whether they be the ingredients or they be the steps of the cooking step, like boiling, cooling, mixing with water, heating, deep frying or stir frying or doing this, or steaming it or something. All these building blocks are commonly done, right? Everybody knows frying, steaming, heating it or roasting it on a tawa. Yeah, everybody knows you can use mirchi, you can use turmeric, you can use jeera, dhania, sugar, salt, the sour elements, khatta items. Everybody knows you can use rice or wheat or dal or rava or bajra or jawar or corn. All these things are known. People are making things in various combinations. Okay. And when somebody uses a particular combination of ingredients and steps, what the dish or the food item that comes out in one case, one combination of ingredients and steps followed will give you a samosa. A different combination of steps and ingredients that you use will you give a masala dosa, right? And another combination, if you use, you will actually get a pani puri, right? But all the ingredients, all the steps being done there are all known, right? So can a recipe be patented? My answer to that usually will be no. Why? Because there is no technology innovation. Okay. What's the difference between a samosa and a masala dosa? It's basically the taste. Okay. I will like a samosa. You may say, I prefer a masala dosa. So I will eat I will eat samosa, he will eat masala dosa. And there is no technologically really some innovation in this. Only my personal taste preference is for samosa and their preference is for masala dosa. Somebody else will like dhokla, somebody will like misal pav, somebody will like biryani, right? So there's not one, it's not that technologically biryani is a technologically advanced product compared to a samosa. Nothing like that. Some people like to have, again, human beings are emotional beings. Some people like certain taste. Some people like spicy food. Some people like sweet food. Some people like salty food. It's just a matter of personal preference. There's no technology differentiator there. Do you get this? A samosa is not more technologically advanced than a puran poli. They are just different ingredient, different steps in different permutation and combination, and taste different. Certain people like this, certain people like that, right? There's no technology advance. Therefore, usually a recipe or a method for making a dish or the dish itself will be very challenging or difficult to patent that, because there's no technology advancement there. right? Now the recipe itself. Now imagine there is some famous chef, maybe Sanjeev Kapoor or Tarla Dalal or something, and for a particular dish, they write down the recipe. These are the ingredients, and then you take this, do like this, and do these steps, and mix like this, heat like this, cool like this, fry like this, and then you get the dish. Now they have written down these instructions. These are the ingredients, these are the steps, and at the end, if you follow this, you will get this. Now that's a recipe, and it's in written form. Can you see it's an expressed work? So you can very well get a copyright on that recipe. Can you hear what I'm saying? Did you get what I'm saying? I'm saying you can get a copyright on that recipe. Okay. Now, what does a copyright on recipe mean? Somebody else can't make a copy of that recipe without permission of the author. Okay. Right. So they can't make copy. But suppose I get to read somebody else's recipe, I will not make a photocopy of it or a Xerox copy of it. I'll not do that. But I read the recipe. Now it's uploaded in my brain. So I go to my house and I prepare that dish as per that recipe. I haven't copied that recipe. I didn't make a copy. I didn't note down in my notebook. I didn't make a photocopy of it. It's just in my head, and I cook in my house. Do you think there is copyright infringement? No, there is no copyright infringement, even though I'm copying his copyrighted recipe, because I didn't make a copy of his document. That express work, I didn't make a copy. I'm just using that know-how, which is already in my brain, right? So copyright protection, can you see, is weak. You can prevent others from making a photocopy of that document, but you can't stop people from using the ideas which are there in that document. So even a copyright protection is not good to protect recipes, right? So largely speaking, it's very challenging and difficult to protect recipes. Okay. Now, what kind of a scenario can some food item or some recipe kind of a thing be protected? Can you imagine any scenario where some food item can be patent protected? Just think about it for a minute. Okay. And I'll give you an example of this. I actually had some years. Yeah, somebody wants to say something?
If served in any restaurants,
Okay, but what's the technology innovation if some food is served in a restaurant? What is the technology innovation which you'd like to patent? Somebody cooks as per a recipe in a restaurant. That doesn't make it patentable, right?
yeah.
Yeah. So let me give you an example. This is really, I'm sharing actually what happened. Okay. Many years back, I met a person who was a food technologist. Okay. He was specialized and skilled in terms of making food items and what are the factors involved, etc. Technically speaking in that. Okay. And as far as I remember, what he told me was the Indian army had a certain requirement. Okay. Very often these soldiers, the Jawans, they are posted in very remote locations, very far away from any civilization, maybe in a forest or desert or some cold place, some out of the way place on the border somewhere. Okay. And they have a problem of getting fresh, tasty food. In this case, it was a chapati. Chapatis without proper refrigeration and protection will not last for 4 months, 6 months, or 8 months, right? So they came to this expert, this food technologist, with a problem. Can you make chapatis, or can you tell us or invent a method or some combination of ingredients which will make the chapati last in such areas for 6 months without any refrigeration, without anything else? And after 6 months, when the soldiers eat it, it should not be stale and stinking and not edible and should not cause any problems for them, right? This was the challenge. Now this person actually went there. I think it was, the location was somewhere in the south, maybe in Kerala somewhere, and he actually worked on that, and he came up with that recipe. What he came up, he didn't tell me. Okay, either it was the recipe or the methodology or some new ingredients which he might have used in that, and he actually came up with such a chapati based on these requirements. Now there, my question to you is, do you think that chapati or that recipe or some method of making it or the combination of ingredients in that chapati, do you think it can be patented? Anybody can unmute and answer this. Do you think that chapati or the way of making it or the ingredients in that, can that be patented? And whatever your answer is, you should also say why you're giving that answer. If you're saying yes, then you should say why. If you're saying no, then you should say no. Anybody? Okay, so let me give the answer to this. Yes, that thing can be patented. I don't know what that thing is, But one thing I see, there is a technical process or in combination of ingredients which is being applied over there. There is a technically different result. This chapati for 6 months doesn't go bad, it doesn't get stale, it doesn't become inedible. So there is definitely a new technical result, and some new technical process or new ingredients or combination has been used, okay, to make this chapati last so long. Can you see there is a technological innovation? It could be a product innovation, it could be a process innovation, or it could be a combination of product and process innovation, but there is a technical innovation. Can you see that? Such things, such food items can be patented, right? So I hope you get the difference between merely patenting recipe, which like कोई बोलता है इसमें इतना शक्कर कम डालने का, इतना मिर्ची डालने का. That is not a technology, it's his personal taste preference. That can't be such a recipe can't be patented. But something you are doing based on certain technical factors and which gives some technical results, such food items can be patented. I hope this is very clear to you, because very often I get asked this question: can recipes be patented or copyrighted, and what to do about that? I hope that is now very clear to all of you. What else related to food technology can be protected? You can protect some new innovative utensils. Okay, if it's merely a good looking shape you're giving to a kadai or something, then it could be industrial design registration. However, if you add some particular inner layer to that kadai such that the food does not stick, then that technology innovation improved product can be patented, right? It's a functional benefit. There's a new technology involved that can be patented. Same thing applies to machines. If you make the machines, say like a chapati making machine or a cooker or a heater or a frying some arrangement or a baking machine, there are very often huge baking machines people use in industries. If you make the machine look good, you'll apply for an industrial design registration. If you make the machine work better, maybe consume less energy while cooking, then you'll file for a patent for that method or that physical machine product design. Okay, so it could be product invention or it could be method or technique invention. Apart from that, food, very often manufactured food uses packaging. Right now, if you come up with different packaging which either looks good or it is designed functionally better such that that packaging preserves the food for a greater period, not 1 week, but if you pack this way using this kind of packaging, that food will last 1 month instead of 1 week, then such packaging can be patented. A good looking different shape, like the pizza boxes you see, there are so many different shapes. Somebody comes up with a different shape to their pizza box, they can get at least an industrial design registration on that. Okay, and on top of that will be the logo, the branding, those should be trademark. The machines can have their logos, utensils will have their word mark or logos and the branding, so you can trademark all these things. So can you see in all these things, there are many types of things related to IP protection that are possible. Depending on what is relevant for you, you will apply for those kind of IP rights in that particular situation. Okay. Now let's come to the last slide. Okay, right. Now this is a slide which just illustrates that one thing or one product or one thing can have multiple IP rights relating to that. Okay, single product, multiple IP rights. For example, here you see on the left side a bottle with some specific specialized drink in it. Okay, so patent will protect the process of making the drink as well as the final product as long as there is a technological innovation. Can you see the design of the bottle is different? It's not like a normal plain bottle. It has a specific design of the bottle which will be protected under industrial design. You can protect it. The trademark protects the name and logo of the drink. The Welch written in a certain style as a logo mark, that can be registered as a trademark. Any jingle, means a song made for advertising this drink, can be that song itself, song recording, that jingle recording can be protected by copyright. And if this drink, for example, is made from grapes specially grown in a certain region of the world, then it can have a registration or protection as a geographical indication. Means in this case, the registration is for the word Concord, because these grapes which are used to make this drink are grown in the Concord region of France. Okay, so any drink which is made from grapes grown in France in the Concord region can be called as a Concord drink. That's a geographical indication. A geographical indication is an intellectual property right which indicates the source of geographical origin. Geographically, where was this product made? Where did it originate from? That is identified by a geographical indication. For example, in India, we have different types of rice, but basmati rice is a particular variety grown in certain parts of India, North India, and certain parts of Pakistan. If you take the basmati rice seed and go to Kerala and plant it and grow there, you can't call it basmati. Okay. Similarly, Kolhapuri chappal, that's a geographical indication. If you take all the leather and the materials required to make a Kolhapuri chappal and you hire a person who is expert at making Kolhapuri chappal and make him sit in Pune with these materials and make the chappal in Pune, that chappal can't be called a Kolhapuri chappal because it was not made, it was not grown in Kolhapur, it was made in Pune. So then it's a Puneri chappal if at all. It can't be called a Kolhapuri chappal. This is what a geographical indication means. Okay. So I hope you've got a sense of the various main types of intellectual property rights, what kind of intellectual property it can protect and why. Okay. And what is the relevance of it. Also prioritizing and filing IP rights only when it makes sense to you or your company or your venture. Okay. Just for the heck of it, for getting certificates, don't do that because it costs time, effort, and money. With that, we come to the end of this session. We've gone a little over time. I apologize for that.
Thank you, sir. It was very informational. And the session is open for Q&A. If you have any questions, you can put it in chat box or unmute yourself. I would ask Sujata ma'am to unmute if I think you had some questions.
Good evening, sir. I'm
Good
H.
evening,
Singh
sir.
from Chandigarh.
Good evening, sir.
A very nice program, sir. It was very informative, very kind of you, very enthusiastic. Good.
Who, me or the audience?
You, sir. You, sir.
Okay. We need
Nice
the audience
it
to
is.
be enthusiastic.
True. What are the prices probably of your services, if you could give an idea? Because accordingly, they have to be ready with these things.
Okay. Right. We don't have enough time, so let me quickly give a sense of this. Okay, patents are technically the most challenging. They take most time. More effort is involved in preparing the patent specification, also conducting the examination in the patent office. So that costs the most. Okay, if you file for a patent application, assuming it's a natural person applicant filing through us, the cost of the entire process, not just of filing but subsequent prosecution till the final decision of grant and rejection, would be approximately in the range of 1 lakh to 1.5 lakhs, everything included, assuming no unusual activity you do or no extra steps you do. Okay, this is just indicative. If you do it with us, other firms may have their own rates, charges will be different, so this may not apply, but just to give you a sense, that would be the range. Comparatively, copyright is very simple. They don't really examine it. It's a very simple procedure that may cost maybe 5, 10 or 15,000 rupees at the most. Usually it should be within 10,000. Okay, or sometimes it can even be 5, 6,000. Okay, can you see the difference? Patent and copyright, there's a big difference. Similarly, trademark also costs much less than a patent. Maybe that cost for a natural person applicant, the whole process may be about 15 to 20,000 rupees per mark per class, right? And industrial design registration again will be about 10 to 15,000 rupees for a natural person applicant, including both the official fee of the government IP office as well as our fees if you do through us.
Can you repeat the industrial this one, sir?
That would again be in the range of say about 10 to 15,000 rupees. Although if there is some additional objection or opposition, the cost can go out, but usually it will be 10 to 15,000 rupees range.
Very nice of you, sir.
Yeah, these are not like exact things. I'm just giving a rough sense because the exact amounts will depend on what exactly is your work, what you're doing, what options you go for, who's doing it. All these factors it depends on.
Very kind of you. Maybe we'll through Diksha Shetty, ma'am.
Yeah, you can contact me. My
coordinate with her.
email
Yes,
ID
yes,
is on the screen.
definitely. You can note down Sir's email ID. It's not necessary you have to go through me.
All right, ma'am. Thank you.
Okay.
Thank you,
Okay.
sir.
Thank you.
Okay. I don't think we have any questions, so I would request Hemlata to raise a formal vote of thanks.
Yes. On behalf of Chamber for Advancement of Small and Medium Businesses, I thank Mr. Parvez sir for his valuable time and excellent and informative presentation. Thank you all the participants for joining. Thank you.
Thank you so much, sir. Thank you for joining.
Thank you. Can I say something?
Yes, sir, sure.
Yeah, thank you, Diksha ma'am, Anjali ma'am, Himlata ma'am, and the entire team, Nilesh sir, and everybody involved for giving me this opportunity for all your work in arranging all these things. Thank you so much. It's been such a pleasure. Last but not the least, I thank all the participants and people who are watching this for your time, attention, and your participation. Thank you so much. It's been a pleasure.
Our pleasure, sir. Thank you so much.
Thank you. Thank you.